I've been joined on stage by Patrick Daniels, co-founder and chair of the Securities practice at DiCello Levitt in California, to talk about the emergence of investor claims as an alternative asset class. Patrick has advised funds and fund managers around the world, including in the US, UK, Europe, and Middle East, on securities, corporate governance, and fraud. So, welcome, Patrick.
Thanks very much. Happy to be here, and congratulations on such a well-attended event, well-organized. Thank the team for that.
Great. Well, look, everyone here is familiar with class actions, with investor claims, and with third-party funding. But can you explain the emergence of investor claims as an asset class? We've got a securities panel tomorrow, but this sounds like something a little bit different from that.
It is. This is sort of where the business is evolving, and some very recent. I'm going to jump around on this. We only have about 6 or 8 slides here. This is treating investor claims as an asset class has been something that's been debated within the larger funds and with practitioners like myself for the last several years, and it's just the debates have gotten a little more serious, and we can announce here exclusively, Andrew, that 2 of the largest public funds, they haven't put out their press releases yet because we're developing the processes and the analytics. I saw somebody from Cornerstone's here. Maybe they'll be brought in to help. But 2 of the largest U.S. funds are formally adopting the policy to treat investor claims. So they're claims in class actions, whether they're just passive filers or some of the antitrust financial products cases that you've seen in the last few years that were just mammoth. I know some of those are being pursued here, not quite mirror versions or copycats, but similar. But this discussion has accelerated to the point where big U.S. public funds are going to treat these claims as an alternative asset class. Let me just jump back to the end here, and then we'll come back to the data, Andrew. There we go. So I think we need that one. So this is no longer a theory, it's a reality. And the significance, when we go to a board meeting, the lawyers may get 3 minutes to kind of summarize how the case is going and what's happening generally. But now when you move investor claims over to the fund management side within a big pension system or a sovereign wealth fund, then you get monthly, it elevates the importance of the subject matter because the money gets tracked more closely. And for some of these large funds, you're talking tens of millions of dollars a year. And they think in terms of, the fund management people think about it differently. They treat it as an asset. It gets quantified more clearly. Those reports go to the board every month, whereas I might be asked to show up twice a year at a board meeting to give my 5-minute summary of how the case is going. But this is going to be reported now to the board every month, quantified, and you'll see I have some data, and then we'll develop more and more data. That's what they're developing now is the procedures for what it is they're going to report.
So why have they done this? Why have they moved from these large investors? Why have they moved from the legal side to the fund management side on these claims?
Better data. So what's happened with education and large cases, in particular, as I mentioned, the antitrust financial products cases, a lot of those settlements, which were massive, in the billions in the aggregate, the products didn't have a QSIP. So if you were doing FX, you had to just get your FX portfolio, and it was immensely complex. If you're doing the credit default swaps, the IS to fix, whatever the financial product was, outside of some of the fixing of the spreads in the bond cases, you didn't have a QSIP, so your custodian, it was completely helpless in filing those claims. And so the big players, the big fund manager, or big funds and big fund managers really came to appreciate professional third-party claims filing firms like FRT, ISS SCAS, Broadridge is here, Batea in Connecticut in the US, IP here in London, institutional protection, they're pros. So and once you've got into that world and have a professional third-party claims filer, your recoveries from the class actions were significantly higher. A lot of, in particular in the US, a lot of pension systems kind of just do a tag-on to their custodian contract and just say, oh, we'll have the custodian file the passive claims. No offense to the custodians, but it doesn't get done correctly. The data is not checked, whereas you have a third-party professional firm, they know before they put your claim in what you should be getting back, or they know what your allowed loss in that settled class action already is, because they do sophisticated analysis, and then they're able to make sure that every transaction is counted, that what the claims administrator says is the allowed loss matches what the third-party claims filing firm says it should. So you're just getting more data points, more sophisticated data, and therefore higher recoveries. And that just elevates the investor claim with data. You know, I'm sure the Cornerstone people understand that. And so what that also does, and then and the data is really hard to come by. Which, is it the one on the left that shows?
Yeah.
Okay. So this, briefly, so one of the best states in the US in this area as far as data, and the CIO of this fund is the North Dakota State Investment Board. And they are the fastest growing sovereign wealth fund in the US because the money that goes into that is oil and gas sharing revenue. And so they had 13 years of their class action recoveries, just passive. And if you average, and you do need a big data set. And so when we averaged out their recoveries, and we calculated the percentage return against the AUM, because we had that data. We'll talk about that with some others. And the CIO, when we ran the numbers and came up with an average, just passive class action filings for a big major US fund that's broadly diversified, is about 20 basis points per year. I was at an event speaking with CIOs, and I asked one CIO of another big state fund, you know, if you had a fund manager that was producing 20 more basis points on average than another one, what would you do? Because I'm the lawyer. I don't necessarily live in this world. And he said, oh, I'd give him more money. You know, 20 basis points is he goes, we live and die on basis points. And these are just the passive claims. So one of the things we're going to be looking at, we've been asked to help the big state funds that are creating this asset class, is do we do the class action returns against the AUM, or do we do it against the individual allowed loss in each settled class action? The answer will probably be both. But you can see that data point. You want to see how much you're recovering against your allowed loss as well. This is a recovery against AUM. So you're going to have a much smaller basis point number. I'll bet we'll see double-digit percentage, like the Petrobras case in the US that settled for, I think in total at the end of the day, it was about $2.7 billion, right in that vicinity. That was a very good recovery. My calculation of the class-wide damages and that against that net recovery after fees was about 22%. So that's what you want to see too, is the return against your losses.
So that change in data, maybe moving on from AUM to other ways of looking at it, will that become more possible as time goes on and you gather more data and that continues to grow?
Well, that's where, when you were saying what is driving this, and what's driving this motion is better data, more data. And the only way we're getting better and more data is from the professional third-party claims filing firms. This data right here from North Dakota is from FRT. ISS Gas was kind enough to share. Now, I only got 1 year of data from them, and then you can see we anonymized who, of course, they can't share their confidential data. They anonymized the type of fund, and then they didn't want us to be able to guess who they might be, so they gave us a range of AUM, but that messes up my basis point calculations. But you can see these numbers are consistent with North Dakota. It's not an anomaly. Of course, in the hedge funds, the question is concentration. You know, a broad or a state pension system in the U.S. or a big sovereign wealth fund, they're broadly diversified. So that means they're buying all the problematic companies along with the good ones. Or, you know, if we knew what the problematic companies were, we'd take them out of the index.
So you mentioned that funders are paying attention to this. So third-party funding that
Well, here's the natural evolution. So you can see the returns. So that justifies the professionalization of the claims filing. Now, let me just look at some other data here. I'll show you. So what this proposition is, so the gray is the median returns of class action securities cases in the United States that are led by individual investors, so mom and pop or a small business. The blue is the average return where there's an institutional lead plaintiff. So it's a significantly higher return, and that tells us that institutions, when they participate in investor claims, get higher returns. And you don't have to be a lawyer to kind of think why that may be. Common sense, the defendant perceives the plaintiff as more sophisticated, having bigger resources. You know, we had some discussion about attorneys general in the United States getting into your cases. Some of the public funds in the U.S., while independent boards, their chief legal officers are the attorney general. So when I bring a case, I'm bringing it in effect as a deputy attorney general, or I report to the attorney general's office. Well, companies are just naturally conditioned to be more wary of attorneys general because they're also the chief prosecutor in the state. And so there's the other thing is, you know, judges are people too. So if you have an institutional fund, say for state teachers, it's the teachers' retirement money and savings. So the judge is like, wow, these teachers really, you know, there's a little more empathy maybe naturally. The judge, like I said, judges are human as well. So, and the company is thinking about how many teachers are going to be testifying in trial about how they lost their retirement money, or we'll have depositions where there's a teacher responding to those questions. So it's a little bit common sense that the institutions recover more in these cases. So that's that proposition. Well, the other thing that you look at, or that we look at, and many of you have probably seen this is the total aggregate recoveries in the U.S. annually in securities class actions, investor class actions. So more or less over the last 10 years, you could say $4 billion is recovered on average. Well, what's the where is that money? And this is a study of distribution of the size of settlements. And what this tells us, now this was a snapshot, but this is true every year. This might be another thing for Cornerstone to add to track. Is essentially what we say is 90% of the money is in 10% of the cases. So most of the money is of that $4 billion annual average that's recovered is concentrated into a few large cases. So what that tells us is we can then focus on the 10 for large, big investors. You know, the CalPERSs of the world, the New York Common Fund of the world, big fund managers, can look at those 10 big settlements, which are usually going to be large cap companies, and say, how can we get more out of this class action? And the natural evolution of that is to look at direct actions or opt-outs.
Well, I wanted to ask about that.
So that's stepping out of the class.
So if investors are increasingly looking at stepping out of the class, is that going to, over time, disincentivize class actions? Will we begin to see a bit of a downturn in that market because more big investors are looking to bring individual claims, direct claims?
No, because the appeal, once a company decides they want to settle a case, the class action becomes their best friend because you get a broad release of liabilities. But they are still going to have to deal with the larger, I'm talking the larger sovereign wealth funds, maybe large hedge funds, the largest of the state plans in the US and internationally, of course. There are big Dutch funds that are big investors in the US, and they've done direct actions already. But when the other factor in that is that the fund management, now that the responsibility to track and follow through with the investor claims and class actions in the US is on the fund management side of these organizations versus over in the legal office. Well, the fund managers then start to treat it like any other asset, and they think, or like a PE, say, hey, we've got to do 10 deals. Maybe we break even on 2, we lose 1, but I want to make we'll make solid, excellent, superb returns on these 7. So see, you're going to see a proliferation. Once they're in that asset class, then the fund management people are going to want to reach for that return. I saw a question come up here. And interrupt any time. It's okay. We're just having a conversation. Yes, sir.
Yeah, I feel like I'm hearing 2 things, and I want to see if
Yep.
I'm mistaken. You're talking about investing in litigation as an alternative asset class.
No.
And now you're talking about the pension funds being a plaintiff because they invested in the company, and as a shareholder, they're suing.
I'm not talking about investing in funding class action lawsuits. No. I'm exclusively saying that the investors, the class members who are buying stock that then, there's a fraud, goes down to the investors who bought Enron are moving these claims from the legal office over to the fund management side because they're treating them as an alternative asset class. They're formally designating legal claims in the companies in which they invest as an asset class. And once you do that, and they're able to do it because there's a better source of data, what their claim is, their allowed loss, what precisely they're recovering, they're tracking it much more accurately and seeing real results. Like what I was pointing out, that just was a passive claims filing program in North Dakota that returned 20 basis points per year on average.
But then how would they choose to invest more money in that type of exposure? It seems like they're more of a victim of the exposure.
They are. And that's why they're plaintiffs in the class, or they're plaintiffs or claimants in an individual or direct action. Instead of staying in the Enron class or the Petrobras class, they step outside with their $100 million in losses, whatever they lost, and they sue Petrobras directly in the hopes of getting 50% recovery, 40% recovery, etc. And that's what I'm saying. The fund management guys will start to look at class action claims like private equity, and they'll say, hey, we've got to do 10 of these in the hopes that 7 pay really well.
So I want to ask you another question about that. And then if anyone else has a question, we'll come back in a couple of minutes. So feel ready to put up your hand or send one in via Slido. This being the case then, how does this change the dynamic between the investor, the funder, if you like, and the litigation team? We're used, certainly the people in this room are very used to the relationship between the third-party funder and the party, the claimant, plaintiff, and the legal team. But now if they're treating this, investors are treating this as an investment class, and they're being more involved, perhaps they're having more updates, as you say. So how does it change that dynamic for the litigation?
Well, typically in the US, in the plaintiff's securities bar, there is bank funding, but there isn't, the cases, it makes them difficult to do litigation funding of a securities class action. That is not typical. But on an opt-out or direct action, since it's one plaintiff, one investor, one case, That's the opportunity for litigation funding. And in fact, I haven't looked at everybody's site, but I did listen to a Burford. They did an opt-out survey of about 300 or 400, I guess, in-house counsel about opting out or doing direct actions, the sentiment toward doing direct actions in commercial litigation, which includes securities. So, for example, the Visa swipe fees. There was a massive class action in the U.S. That settled for billions of dollars over deceptive charges of the swipe fee, the 2 or 3 cents on the dollar that you pay when you use your credit card. Well, in that case, Walmart brought an individual case, obviously because of the size of their claim, under the same rationale that a large investor would do a direct case in a securities case. They want to get a higher percentage recovery than they otherwise would get in the class action. That's what the motivation is.
We've got about 4 minutes left. Have we got any other questions for Patrick at the moment? In which case, and feel free to put up your hand if you have one in the next few minutes, in which case, given that this is an emerging asset class, if we're sitting here again in, say, 2 years' time, what do you think you'll be saying about this asset class then? Will it still be on track with many of the things you've talked about, or will something else have evolved out of this?
The two funds that I'm talking about are very, very influential internationally, and they're very active at, say, ICGN, or they send representatives to a lot of the international investor conferences. So that will have and they're already influential. What these two particular funds have done, I'm not trying to be secretive, but they haven't made public announcement yet. When they make changes to their private equity policies, a lot of funds, it kind of just ripples across the world, where a lot of other major investors, APG, PGGM, the sovereign wealth funds will say, let's see what CalPERS is doing with this area. And you'll see, or New York Common or something, you'll see those changes being made. It's also going to impact the fund consultants who help funds hire managers. They're going to have to adapt to what are the fund consultants going to say about this alternative asset class once it's formally adopted by two of the more influential funds in the U.S. So that will have a ripple effect across the fund management side and throughout the plaintiff's bar, and we'll have more opportunity. There'll be more encouragement to file more direct cases with the idea of recovering a higher percentage of your losses than you do by simply staying in the class.
And again, you talk about moving this from, say, from the legal side to the fund side of the business. Is there a good understanding on those teams, on the fund side, maybe the investment side of the business, of the different issues at play when you're bringing a large piece of litigation, a large class action?
Yeah, it's going to be a learning curve for everybody. Now, if I was the legal office, I would have fought to keep those claims and turn the legal office into a revenue stream. So I think some of those lawyers are going to regret that. Instead of being a cost or an expense, they could have been a revenue source. But of course, the legal officers will still weigh in on any proposed litigation. I just think it's the decision of how many to do will be driven by the fund management side.
And do you think this is a good thing overall for the class actions discipline? We're going to hear later today some concerns about the way litigation funding interacts with the conduct of class actions. So will this create any concerns for legal teams, for parties, or even for the courts about the way that investors are involved in this process now?
Well, I can't file an opt-out direct action for my client if I'm the lead counsel in the class case. That's a conflict. So you will see some of the plaintiffs bar, if there are more opt-outs filed in a case, you'll hear some grousing and complaining about it. But now I'm back to what's our target market here, and it's really those 10 major cases that are going on, and every year there may not even be 10. I'm talking, these are the mega cases where, class-wide, you're $1 billion plus in damages. This is only going to be attractive, or the direct actions are only attractive for the larger investors with the largest losses, and those are those mega cases.
Sure. Okay, well, it sounds like there's plenty more to dive into here. So if anyone would like to talk to Patrick, do track him down in our next break. And we also have a securities panel later on in this event, I think tomorrow, where we'll discuss maybe some more issues in relation to this. But thank you very much, Patrick.
Thank you.